so we filed a petition. And this petition doesn't speak the language of racism, the language of the doctrine of discovery. It speaks the language of human rights. By unilaterally granting rights and interest in the lands of the Hul'qumi'num people to private third parties without consulting them. You can see, I'm getting everything in here. Okay, I'm getting the right to consultation, I'm getting property rights, this is how you gotta do it. No offer of restitution, payment of just compensation, permitting damaging logging and other development activities, occupied and relied upon by the Hul'qumi'num for their cultural survival. That's all I'm focusing on. That's all this case focuses on. That what you're doing in Vancouver is leading to the ethnocide of the Hul'qumi'num people. You are going to wipe out every last tree and they'll have no land upon which to practice their sacred relationship and their unique land-based culture. And this is some of the evidence we offered to the commission at the admissibility stage. So at the admissibility stage, you've got to prove one thing. This was our challenge, and we had our admissibility hearing in 2009. You have to show that you've exhausted domestic remedies. As one of the Hul'qumi'num people said, I'm exhausted. No, that's not what they mean. Okay, unfortunately, that's not what they mean. What they mean is you have to go through the Supreme Court, all the way to the Supreme Court. However, there's an exception. The exception is you don't have to exhaust domestic remedies if we can prove that Canada's remedies are ineffective to protect your right. Do you realize what that meant? That meant that my little law program, the Hul'qumi'num, were going to go before the Inter-American Commission and charge Canada, which provides the second most funding to the Commission in the OAS, and which brags about having the most sophisticated legal system in the world, and which brags about what a great job it does to protect due process, and which puts out the Inuit there. Well, we gave them the whole Northwest Territory. We have Delgamuukw. We had to convince a body of 7 independent human rights experts, most of them elites from Latin American upper class folks. We had to convince them that Canada, their wonderful legal system and treaty system, could not produce an effective remedy. And we filed a 30-page petition, and Canada answered with 1,200 pages showing how effective their remedies were. And what we showed the Commission was what was happening while Canada was dragging out this process. Those areas in red are proposed subdivisions that have been approved by the Cowichan Regional Valley District. Is that our CRVD? And the other areas are how Canada and BC allowed private lands to be clear-cut. There's no regulation because you own it. It's your private property. Canada acquired it under the doctrine of discovery and sold it to you. So we can do anything we want to it. When I showed this picture, the ambassador from one of the Latin American countries came up and says, it looks like the Amazon. Okay, that's what it looks like. I said, oh, it gets even better. That's what it looks like. We took a plane up and we had hundreds of pictures of this indiscriminate clear-cutting. And what that does is just ruin wildlife habitat. There's a stream at the bottom there. You have siltation and dirt laying down. It dams up the streams. Salmon can't get back up there. It's absolutely ruinous. All the trees, all the traditional medicines, the gatherings, the sacred watering holes where the Hul'qumi'num perform their sacred bathing ceremonies, just obliterated by this development. And then, of course, once you clear cut it, and all the timber's for crap because it's all beetle blighted, it's just chewed up in pulp and sent over to China and Japan. Well, now you've done a great job for the real estate developers to come in. And in fact, they did a great job. This was evidence we introduced. Why all of a sudden, this is what I get asked, why are they so upset? Where have they been all these years? Well, what happened was all these folks from Toronto and Montreal were coming out and buying nice little vacation homes on Vancouver Island. And so in 1998, you only had 52 subdivision applications. And then look what happens from 1998 to 2007. A 15-fold increase. From 52 to 752. And the subdivision applications were getting bigger. And so our argument was that if you don't stop this, if you don't make the government stop cutting down trees while they're in negotiation or in litigation, there ain't going to be no land left for the Hul'qumi'num to practice their culture. And that's why it's not so special case. That's the same case for all the First Nations on Vancouver Island and all the First Nations on the mainland. That by the time your treaty process and by the time your courts get around to issuing a final decision, there ain't going to be no Indians around. So I'm finished almost. This was Canada's argument. Canada argues that HT's petition is inadmissible because we've not exhausted domestic remedies. Hey, you can go through negotiations under the BC process, or if you don't like those, you can sue. And so we took a lot of risk. You know, as a lawyer, you never want to make one of these definitive statements that could be, and I asked Robert, and I asked the lawyer, I said, are you sure of this? Because I could not find a single case in the history of Canada that had awarded one single square inch of Aboriginal title where the land had been owned by private parties. Couldn't find it. I said, Robert, I'd love to be able to say that. You know, that 1 square inch, that's a really, you know, that, can I say that? Yeah, I think so. And I was really anxious. I was afraid that Canada was going to find some exception and make me not look credible. This was their argument. The fact that a Canadian court has not made such a specific declaration to date does not demonstrate a Canadian court never would in a properly pled case. Now you know why I'm so emotional. Okay? Am I forgiven? Do you forgive my, you know, it's hard going against Canada. I had no idea. You know, I thought other than hockey, you people were pretty civil. I mean, I didn't understand. But it's hockey with you guys all the time. We're getting crashed into the boards, man. And so this is what the commission found in the admissibility report. For the first time ever, an independent human rights body looked at, evaluated through 2 years of hearings and evidence, both Canada's treaty process and its judicial system. We had to go 2 for 2. It wasn't enough that we could prove that your treaty process was ineffective. We also had to prove to the commission that your legal process was ineffective. And so the ruling on treaty process is as follows. It's not allowed negotiations on the subject of restitution or compensation. Remember, compensation is not on the table for HCG ancestral lands, which make up 85% of their traditional territory. Since 15 years have passed, and the claims have yet to be resolved, the third exception to the requirement of exhaustion of domestic remedies applies due to unwarranted delay. Basically, the commission says you've got to resolve a claim, any type of claim, with 3 to 4 years. Canada came in there and thought they'd get away with 15 years. I felt pretty good on that third exception, but then, totally gratuitously, they gave us this ruling. By failing to resolve the HT claims with regard to ancestral lands, the BCTC process has demonstrated it's not an effective mechanism. Now do you understand? What, after this type of ruling, and this wasn't anything that indigenous people didn't know, they knew it. They knew it wasn't effective. Why would you sign a treaty negotiated under an ineffective mechanism? And it's not their opinion, it's the opinion of 7 independent human rights experts who said the BC process is ineffective. Therefore, the first exception to the requirement of exhaustion of domestic remedies applies because, listen, there is no due process of law. Every Canadian should be ashamed that in the 21st century, you don't even provide due process of law. And I know you're all here because you're sympathetic. I'm preaching to the choir. But I don't think that the choir is his understanding of the depth of the crisis that Canadian society confronts. Okay, felt real good about that. Now I was worried and reading down there. I knew that, and we all knew that we were probably going to win on the BCTC process. What we were really worried about was the Canadian legal system. And so here's what they held. The commission considers the relevant experience, and this was great because we said, look, Canada in those 1,200 pages will say, why is Hul'qumi'num going to the commission? We've had Hul'qumi'num. We had the Delgamuukw tribes. They went to court, and they all got due process, and so they cited, I think, 8 or 9 First Nations in BC that had gone to court, and they said they got these due process. We got every one of those First Nations to file an amicus brief saying, no, we didn't, we wasted our time. The chief in the Delgamuukw tribe, what was his name?
Glenn Williams.
Glenn, yeah. Or who was it who gave us the amicus? We had one of the guys who helped organize Delgamuukw gave a 5-page affidavit which talked about the fact that after spending $14 million and over 14 years, all they really did was get to the Canadian Supreme Court and be told to start all over again.
It's from the Wet'suwet'en.
Yeah, Wet'suwet'en. And at the final, he said, and so we really felt it was a waste of time. And at the end, again, it was unprompted. He made this great statement. He said, doing Indigenous rights work is really hard in Canada. Okay? And it just made you want to cry when you got to the end of that affidavit. And so Canada shut up on that. And so the amicus came in key for us. They show the difficulties they face when trying to access the legal remedies the state contends must be exhausted. The Commission notes the jurisprudence cited by the state recognizes the existence of the Aboriginal title, the communal nature of Indigenous property rights, and the right to consultation, but the amicus show that none of these judgments has resulted in a specific order by a Canadian court mandating the demarcation, recording of title deed, restitution, or anything. And so therefore, the legal proceedings mentioned above do not seem to provide any reasonable expectations of success, because Canadian jurisprudence has not obligated the state to set boundaries, demarcate, and record title. And so therefore, your legal system wouldn't be an effective remedy over either. Slam dunk. That gave us the opportunity for the first time ever to argue on the merits before an international human rights body in 2011 that Canada had violated the human rights of the Hul'qumi'num people under its treaty obligation of the OAS. And that's where we stand right now. And that's enough. Thank you very much.